I want to welcome everybody to the annual meeting of the Oklahoma Criminal Defense Lawyers Association. For those of you that do not know me, because I'm from down there in the sticks in southern Oklahoma, my name is Michael Haggerty. I've been the president of this organization for the past 2 years, and while it has been a pleasure, I can tell you I find nothing in this presentation more interesting to me than the part where we're going to elect a new president this year. So, we're going to move on and get to that part because that's what I want. I'm the kid that ate his dessert first if he could get away with it. But instead, we have some very good things to go on. First of all is our keynote speaker. And at this point, I want to recognize board member John Hunsucker to introduce our keynote speaker. John?
Hello, I have the honor today to introduce Ziva Brandstetter from the Tulsa World. Ziva has long been an investigative reporter, very interested in criminal law. She is actually the enterprise editor at the Tulsa World and has been there since 1994. She has witnessed 4 executions, including the last one that was botched with a locket. She is also currently the president of FOI Oklahoma, which is Freedom of Information. And they're very active. The Tulsa World's been very active in open records and Freedom of Information Act. Today, and unfortunately, she is a graduate of Oklahoma State University, but we won't hold that against her. If I'd read this earlier, I probably would have one read today just for her. So, and she has 2 boys that are 18 and 23. Today, she's going to speak to us about how Oklahoma carries out the death penalty and the role prosecutors and police play in the recent exonerations. Also, how to use Freedom of Information and open records to obtain documents that have helped in their investigations. Please welcome Ziva Brandstetter.
Thank you guys for having me here today. I was talking to Michael, and I understand you all have a cocktail hour coming up, so I guess I'm the only thing standing between a lot of attorneys and the bar, so I'll try to make it somewhat brief and leave time for questions. I really am honored to be here. One of the things I wanted to start with is kind of compare the job that we do to the job that you do. We feel like in our profession that we are supposed to give a voice to the voiceless, to the powerless, that we should stop government from trampling on people's rights, and that we should ensure that the system is fair. And I think you all agree that's some of the bedrock things that criminal defense attorneys do. Thank you. And we do it because we love it, certainly not for the pay. It's long hours, kind of like, you all do. It's a calling. So I want to talk just right off the bat about a couple of stories we've done recently, and then I want to talk about the Open Records Act, how you can use it. Some of you all may know this, but I've got some tricks that we use, and then finish up with kind of trying to explain the role of the press in these criminal justice stories. And please stop me if you have a question, because I want to make sure that it's give and take. So most recently, we produced a series called Shadow of Doubt, which told the story of Michelle Murphy and her exoneration, her conviction. She spent 20 years in prison when we believe, after everything we looked at, she should not have done that. The prosecutors had the information they needed to know that they were trying an innocent woman. Our findings were that the DA had an OSBI report that contradicted some really important key evidence, had it in his hands the day the trial started. For whatever reason, the defense attorneys did not get that evidence, and the jury never heard it. The DA told us during our interviews that he never saw a 2005 DNA report that would have freed Michelle at that point, and we've pointed out that it was sent to his office, addressed to him, and his assistant apparently read it and didn't tell him about it, didn't realize the significance. So those are sort of some of the key findings, which we've had a lot of reaction to. Obviously, the work of Richard and Teresa Carroll was the main driver behind her freedom, but we feel like we played an important role in publicizing that and letting people know how this happened. So we can sort of work together as partners in the media and criminal defense lawyers. Another story we've done has involved something that John Hunsucker and Bruce Edge have been involved in, faulty DUI affidavits that the Department of Public Safety were filling out. They didn't have the legally required language in them, and so we were able to use public records laws to find out that about 40,000 people would have been ticketed with DUIs during this time. During the many years they were using these bad affidavits, and the Department of Public Safety may owe millions of dollars in refunds. And so this is not the first time this has happened to the Department of Public Safety. They had a similar situation many years ago. I had a story in Ponca City that involved a decorated Iraq war veteran who was accused of the murder of his little boy, and everything I looked at told me that, and I don't make these decisions lightly, but that this was not a good case. And what we found out was that the police in this case and a state child review board member asked the medical examiner's office to consider changing its autopsy findings so that it would help their case more. And we had a tape of that meeting. So it's just some of the things that we've been involved with. And open records have played a key role in a lot of this. Of course, court records are very important. You all know how to use court records. We use them as well. But there are many other records that you can use. So if you'll indulge me to kind of hit some of the key points on the Open Records Act, one thing I know is faster than discovery. Okay, you don't have to have a court reporter there. We use the Open Records Act for backgrounding people and organizations, for preparing for interviews, finding waste, fraud, and abuse, filling in holes in our stories, and checking for accuracy. And you probably know this is Title 51, Section 24A1 through 29. FOIOklahoma.org has a lot of resources on the Open Records Act that you can use, and you can also call FOI Oklahoma and ask them for help with any specific case that you have if someone's denying you a record. The basic premise is that the act is inclusive. I consider everything open unless a public official can tell me why it's not. There are a lot of exemptions in this law and in other laws that someone may be able to cite, but the basic premise of the law is that what government does is the people's business, and those records are the people's records, not the government's. So what is a record? It's a very wide definition. It's book, paper, photograph, microfilm, data files, any kind of data file, sound recording, film recording, video record, or other material, regardless of physical form or characteristic. So email messages certainly would be in that group. That the AG has ruled that those are public. Text messages is something that we haven't really approached yet, but I think we need to. It's interesting because they're probably being deleted and would have to get them from the phone company, and so that's sort of a murky area right now that we need to sort out. Records created by, received by, under the authority of, coming into the custody and control of a public body. So there's a big wide net there that sort of sweeps up all kinds of records. And the public body is one that's supported either in whole or in part by public funds. So some people may tell you, well, we're not a public body. Well, do they get any tax money? So that would be a good argument for saying that you are a public body. Let's see, they have a duty to segregate records that are not public from records that are public. So if you're trying to get some records and someone says, well, I can't give you that because it has a social security number on it. Title 51, Section 24A5.2 says that they have a duty to segregate. And when you're looking at electronic records or paper records, they are supposed to black out or remove the part that is clearly exempt and provide you the rest. They'll often try to mess with you with fees. So just know the law that the law does limit the fees that they can charge almost generally to the direct cost. They can ask you if it's for a purely commercial purpose and charge some reasonable fees on top of that for their time, but generally it's only the direct cost. So that means paper copies, a CD, whatever it is that they directly spend in complying with your request, that's what you have to pay, not some made-up figure that covers the operations of their office for however many hours they worked on it. One really important part of this is that public bodies have to provide prompt and reasonable access. We're having a problem right now with DPS. I'm sure you all are very aware that dash cam videos are now public record. So they have a new policy that says, and this may not be an issue for attorneys, but it's an issue for the media, that you have to mail a request via U.S. mail and get the video back by U.S. mail, which in our business, first of all, we would always have everything after the Oklahoma City media market. But in our business, that's not really acceptable. So there may be a challenge to that policy to see whether that's prompt and reasonable. They always have to designate people who are records custodians. So if you ever are asking for a public record and you're told, well, Susie does that, but she's on vacation for a month, that doesn't work. They have to have somebody there during normal business hours to respond to requests. And if that person is gone, they have to designate someone in their absence. One thing I always advise people is that you can inspect records yourself and just decide what you want copied to save money. So I may go in and spend the whole day and I'll just say, I want to look at every file you have, like on Homeland Security grants, we looked at those. And they put us in a big room and they watched us for a while and then they got bored. To consider asking to inspect the documents rather than having copies, because sometimes they'll try to bury you in copies and then send you a great big bill that you didn't anticipate. So that's a good way to get around that. Personnel records are something that a lot of people assume are pretty much shut down, pretty much not public. There's a large category of personnel records that the state has to give you on public employees. They can keep confidential personnel records if they relate to internal personnel investigations, employee evaluations, payroll deductions, but everything else shall be available, and that includes their employment application, how much they're paid, the dates of employment, title and position, and any final disciplinary action resulting in loss of pay, suspension, demotion, or termination. So basically, if they've done something bad enough to, have gotten them in trouble in their job, that creates a record that you can get. And always be sure to ask for any attachments. They may have some very pro forma letter and then an attachment describing everything, the real stuff that you want to see. So ask for, all attachments. Another thing folks assume is that records in investigatory files or litigation files are not public. There's a specific part of the Open Records Act that deals with this, and it says, access to records which, under the Oklahoma Open Records Act, would otherwise be available for public inspection shall not be denied because a public body has taken possession of them and placed them in an investigatory file. So maybe the city attorney or the DA didn't have to give them to you, but if the police chief says, well, those police reports are all part of the city's internal and personnel investigation. If they're public record, they're public record. It doesn't matter whether they're investigating something. I would assume often when you want records during some situation, it's something that's under investigation, or otherwise, why would you care? So just be aware of that part of the law. One thing is the agencies don't have to create records for you. So try to figure out how they keep them. They don't have to make lists of things. They don't have to make records. Just figure out where and how the pieces of information you want are kept. And even if it's a federal record related to the federal government, if it's in a state agent's hands or city municipality's hands, it's a public record. So how to get the records you want? I always advise be polite. Don't assume that people are just trying to hide things. Sometimes they don't. They're intimidated. They don't understand the law. They don't know that if they have the authority to give this out. That's why I like to ask who the records custodian is and deal with that person. In smaller towns, they won't have someone like that, so you'll deal with clerks and secretaries. And you guys are probably better than we are even at chatting these folks up, at making them your friend and trying to keep it informal and not sort of let it rise to the level of a conflict. But be really unrelenting in your follow-up. So I always keep a spreadsheet of all my ongoing records requests, what date I asked for them, who I talked to, what they said, when they said they'd get back to me. And then I can call them and said, well, on June 21st, you said you'd get back to me, and it's June 23rd, so how's that coming? And sort of, it allows me to track things. I would really advise to ask for exactly what you need and don't go on a fishing expedition, and state the time period you want covered. So also, I always say, I always ask agencies to tell me in advance how much this is going to cost, because again, they'll try to bury you with paper and then send you a bill for it. And then keep copies of all correspondence and who you talk to. When they're dragging their feet, you just remind people that the law says prompt and reasonable, and you don't believe that this has been prompt and reasonable. Ask if there's something you can do to help. Can I come down there and make copies? There was one state lawmaker who brought his own copying machine down to the Ethics Commission and copied a bunch of contribution files, and the Ethics Commission even asked for the AG opinion on whether they had to supply the electricity to this guy. And the opinion said, no, we don't have to supply electricity, but you can't prevent him from bringing in the batteries or something like that. It just got ridiculous. So I think he agreed to pay for the electricity. We have a application called Cam Scanner on our phones, and we can take a picture of a court record and turn it into a PDF with that application. And it's really handy when you're, let's say the courthouse is closing and you've got, half an hour to get this stuff done. And in some of those counties, they're not online. Well, you guys have access to them, I don't. So we use Cam Scanner in a lot of situations to take a picture of a document and store it without having to pay for it. I guess you all probably know this, but the Attorney General's website is searchable. Their opinions are searchable by keyword. And so there's a lot of opinions that have said this should be open, this should be open, this should be open, but it's not in the law. So you can always go to their site and search by keyword and find out what they have opined on. If you're denied, one thing that if you take nothing else away from this, ask the agency to put the denial in writing and to cite the specific statute that they're using to deny the record. They have to have a statute. They can't just say, no, we don't feel like it, or no, you're not entitled to that. They also can't base it on what you want to do with the record. That shouldn't matter. I always contact the city attorney, the DA's office, the assistant attorney general. That's probably going to be a little harder for you all because that's you're sort of in an opposition type stance to them in many cases. But these are the folks that are supposed to be protecting this agency from exposure to civil liability. You can sue under the Open Records Act and collect fees if an agency is violating it. And it's usually a pretty black and white situation. So I would urge you to consider doing that if you feel like you're entitled to some records. Once you get the records, pick them up, even if you don't need them anymore. I think if you don't do that, you train people just to drag their feet and wait till you go away. Check and make sure you get what you asked for. And then I always look through the records and look for references to other documents that I want. Part of the approach I use is, I call it triangulation, which is just a fancy word for people lead me to documents, and documents lead me to people, and those people lead me to more documents, and so on until I feel like I really know the whole picture. And then I always try to call and thank the person who pulled the records together for me, and you never know when you're going to need that person again. So, a lot of you probably have questions about why we report arrests, why we report things in a very early process of the criminal justice system, which I think is a fair question for defense attorneys to ask. So we report on arrests and charges when they're newsworthy, simply put. Generally that's because they involve important people, high-profile crimes, unusual crimes. For example, the Ruby case in Duncan, the kid who's accused of killing his family, obviously unusual crime, high-profile crime. However, the Tulsa World and any media organization is ethically bound to report just as prominently if charges are dropped, if that person's acquitted, if it's a lesser charge that they end up getting convicted on. We always follow up on that. Now, we need, it would help if you all would let us know in those cases, and we try to follow all these cases. But that is only fair, and you should expect that from media that report on these cases. One of the things I want to talk about is interviews and sort of dealing with the media when you have a client that, for whatever reason, becomes a newsworthy story. Don't automatically assume that you can't talk to reporters, that it will hurt your case to talk to reporters, or that it will hurt your client's case to talk to reporters. The DA is going to get his side of the story out. And, we are certainly interested in telling both sides. So you can set up ground rules with us. You can say, hey, I want to sit through this interview, and if my client says something that I don't want my client to say, we're not going to use that. And if a reporter agrees to that, and it should be based on a trust relationship. It should be somebody that you have dealt with or a colleague has dealt with that you feel comfortable with making that kind of promise. Consider making a family member available to talk to us if you don't want to make the client available. Consider giving us a photo that shows your client in a positive light instead of the jail mug shot that we will use over and over and over if it's a big case. So there's just some suggestions from the other side of the equation, is that we want to tell both sides of the story. We realize people are innocent until proven guilty. We don't like just telling the prosecutor and police side of the story. a major role of the press in the criminal justice system is righting wrongs, and that's why I got into this business. Sheila Devereaux is a good case in point. Let's see if I can summarize this. I got an email from a TU engineering student several years ago who said, I really want someone to help my mom. Her last appeal has been turned down, and she's serving life in prison on a drug charge, drug possession, basically. It was a third time offense, and it was a 3 strikes you're out case, and she refused to agree to a rather short plea deal, and the judge prohibited the jury from knowing that she was facing life, and she got life for a very small amount of meth. And this is a woman who, had sort of had a substance abuse problem, needed treatment, didn't need to spend her life in jail with the taxpayers paying for it. But I didn't know what I could do to help this kid. I mean, the appeals were already gone. But I went ahead and I looked at, I asked Bill Brown, who I'm sure all of you know, to bring me back the court records. And I just started flipping through the transcript one day. And I noticed these names jumping out from the transcript that were some of the same officers who were involved in the police corruption case. So we were able to take that, do some stories about her case, and the DA agreed to allow her to plead to a lesser charge, and on the account of ineffective counsel. I think that's the sort of face-saving way that they got out of it. And she's free today, and she's a tax-paying citizen, and she goes to churches and shares her story, and is a friend of mine, and it's a really good outcome. And that was just flipping through court records, basically. That stuff was, hiding there in plain sight. One thing we can do for you all is we create a record of the facts. So, you may not like to see your client's case all splashed on the pages of the newspaper, but if someone's story changes later, the prosecutors, the DA, the police, we have their story that they initially told. We have sort of a set of facts that were espoused originally, so that's something that can provide a helpful record in some cases. So I'll talk a little bit about some projects that we've done and leave time for questions. The death penalty project that we just ran was a 3-part series that ran in June, and it was based on the situation with Clayton Lockett, and I did witness that execution. It was certainly not like the other 3 executions that I witnessed. It was, at the time I was thinking, I can't believe they messed this up so bad, because they had 2 in one night and they knew what a big deal it was, and yet it just all went to hell. One of the things I did is I got autopsies. I got autopsies for 109 inmates who've been executed since we began using lethal injection all the way up to the current one. And we were able to put the data from those autopsies into a database, and we consulted some experts, and we learned a lot about pharmacology and blood levels and all kinds of things. And we found that at least 30 inmates had levels of anesthetic in their blood that was below the therapeutic level. Now, you can't say those people felt pain, but it certainly is a suggestion that they were not properly anesthetized, which is what happened to Clayton Lockett before the 2nd and 3rd chemicals were administered. I've also found out that only 10 out of 50 of them since the year 2000 have received an autopsy. Before that, almost all of them did, at least to make sure that there wasn't any abuse before the execution. It seems like a reasonable thing to do, but in the year 2000, the state of Oklahoma passed a law basically banning autopsies of executed inmates. There was only a couple of cases where you could have an autopsy. So it was interesting to me, and something that came out of this that we had never known before. The other thing we found was that Oklahoma's death penalty protocol is very inadequate, or was, when you compare it to other states. So you look at things like training. The doctors here were not required to go through any kind of training beforehand, any kind of drills. The weight of the inmate is not taken into account when they're prescribing the dose. They just use the same dose for everybody.